Good morning, Ms. Mellon. Good morning, Mr. Gold.
Good morning, Your Honor. May it please the Court, David Gold for the Commonwealth. Joining me at council table is Assistant District Attorney Craig Souza. Your Honors, this matters before the Court on the Commonwealth's application for further appellate review. And that application was filed after the appeals court, in an unpublished decision, decided that the defendant's convictions, several drug convictions in district court, should be overturned because there was no evidence that the defendant signed a jury waiver form, as required according to the appeals court under General Laws, Chapter 263. The Commonwealth doesn't dispute the fact that in the record there's no evidence that the defendant signed a jury waiver form. But that's not the issue that the Commonwealth sought appeal on. The Commonwealth's application for further appellate review asserts that there is no requirement under General Laws 263 that a defendant sign a jury waiver form when he pleads guilty, as opposed to proceeding to a bench trial. I
take it there was a colloquy here on the plea of guilty.
There was evidence that there was a plea colloquy given on the docket sheet. Unfortunately, the district court rules destroyed the record.
That's not an issue here, though, the adequacy of the plea colloquy.
That's not an issue.
The judge sort of recounted what her usual practice was, which was fairly fulsome.
That's correct, Your Honor. To the extent that it is an issue, there is evidence in the record that the judge's customary practice was to give the warnings that are required under Rule 12, and that the plea colloquy was adequate. But the issue here is whether the fact that the defendant did not sign an actual waiver of his right to a jury trial when he pled guilty, whether that alone merits the reversal of his district court convictions. And again, as I pointed out in the Commonwealth's brief, the language of General Laws, Chapter 263, Section 6, when all those sentences are read together, does not seem to contemplate that a defendant would have to waive his right to a jury trial in writing when he pleads guilty. In fact, if you read the second sentence of General Laws, Chapter 263, in combination with the third, the statute itself contemplates that the defendant would actually want a bench trial. In fact, that's what the statute explicitly says, which is that if the defendant signs a written waiver, the result of which is a bench trial. Massachusetts Rules of Criminal Procedure 19 also has the similar language, where it says if the defendant signs a written jury waiver, he will proceed to a bench trial. So, simply stated, there was no support for there was no basis to hold that the bright line rule that this court announced or applied in Commonwealth v. Osborne applied to situations where a defendant actually pled guilty.
I assume you made this argument to the appeals court?
Your Honor, this argument was not explicitly emphasized in the appeals court, but in the Commonwealth's brief in the appeals court, the Commonwealth certainly did mention this as one of the bases. In the appeals court, the Commonwealth responded to the defendant's brief, and in the defendant's brief, he was emphasizing the lack of signature on the so-called green sheet, which in district court is the tender of plea or admission of rights. So the Commonwealth's emphasis was responding to that. However, I will point out that in the appeals court on page 11.
Of your belief in the appeals court?
Yes, Your Honor.
Okay.
First, if the defendant decides to waive his constitutional rights to a trial by jury, General Laws Chapter 263, Section 6, and Mass Rule Criminal Procedure 19A provide that the defendant must memorialize this decision in writing. But if the defendant decides to waive certain constitutional rights and pleads guilty to his charges, he is not required to memorialize this decision in writing. This issue was raised, although candidly, Your Honor, it was not emphasized to the degree that we emphasized in our brief to this court, because we could not at that time have known that the appeals court was going to decide this case based on the written jury requirement and the bright line rule announced by this court in Osborne.
Now, the appeals court seems to rely on a case called Commonwealth versus Castro.
Yes, Your Honor.
Can you tell me about the Castro case?
Your Honor, I'm not prepared to tell you about the I believe the appeals court decision was based mainly on
What they said was, because there was no written waiver, the convictions were therefore invalid. Commonwealth versus Castro, 72 Mass Appellate Court 901, a 2008 case quoting from Commonwealth versus Osborne.
Sure. I'm sorry, Your Honor. Yes. And that case was, and I apologize, but that case was certainly applying the bright line rule that was established in Commonwealth v. Osborne to that case. Again, the appeals court decision was based mainly on the language of the appeals court decision was based mainly on the bright line rule in Osborne, and Castro appears to have been quoting that case. Castro, I'm certainly sure, was not a case where the defendant pled guilty to a crime, and the appeals
No, it was a
court
bench trial.
was a bench trial, correct, Your Honor, just like Osborne was a bench trial, just like Coomey was a bench trial, and just like all those cases that the appeals court cited to were bench trials.
And now, the reasoning of the appeals court's not entirely clear from the short opinion, but I assume that what they were saying is that a waiver of a right to a jury trial is part of a colloquy for a guilty plea. So why would that not impose the same obligation to waive it in writing?
Your Honor, there is no requirement that when a defendant pleads guilty, that they sign any of their rights in writing. So the fact that in Rule 12 that you need to have a warning of your rights to a jury trial, what's important is you're also warned of your rights to a bench trial. And again, that further supports the Commonwealth's position that in that context, it makes sense to to warn the defendant of the right to a jury trial and a bench trial. But in the context of a plea, where the defendant doesn't seek any trial at all, that there's simply no reason for that defendant to waive his right to a jury trial when the defendant doesn't want a trial. And that, Your Honor, is why Chapter 263 and the bright line rule announced by this court doesn't apply to these circumstances.
Well, the bright line rule, so-called, just comes from the statute. The legislature has passed a statute saying a written waiver is required if you want to waive a jury and have a non-jury trial.
Yes, Your Honor. I'm including in that bright line rule, though, the requirement of the oral colloquy. So but I
That was
understand.
an add-on. It was an add-on
Right,
requirement.
but, I
Correct,
mean,
yes.
so, I mean, isn't that the answer, though? There's no comparable statute that requires in a guilty plea that there be a written waiver.
And yes, Your Honor, and that is and that is certainly the Commonwealth's position, that there is no statute, and that the legislature wanted to require defendants who plead guilty to waive their rights to a jury trial in writing for whatever reason. That they could have done so, but they didn't. They wanted, in the circumstances of a defendant proceeding to a bench trial, to at that point know the differences between a jury trial and a bench trial, and to make that decision in writing, so that we wouldn't have challenges to the conviction like the defendant did in Osborne.
In Commonwealth versus Collado, we said that Chapter 263, Section 6, was principally created a procedural rule, and that an unintentional violation of that statute did not give rise to a per se rule mandating reversal. So that if a defendant did not sign a written jury waiver, the failure to do so was, may be error, but he would have to show substantial risk of a miscarriage of justice. It's not an automatic reversal. And I take it your position here is that there is no substantial risk of a miscarriage of justice because he got a plea colloquy. This was included in the plea colloquy, and he waived it.
Yes, to the extent that there would be an analysis of substantial risk of miscarriage of justice, that would certainly be the Commonwealth's position.
How does Collado square with the appeals court cases?
Well, with the appeals court cases, since Collado was decided, and with this court's decision in Osborne, which I believe was after Collado decided, and subsequent cases have since, I'm not sure that it has explicitly done, but it has steered away from the substantial risk of miscarriage of justice or any prejudicial standard because of this so-called bright line rule. Again, that it didn't matter, for example, in Commonwealth v. Osborne, which was a 2006 decision by this court, that the defendant in that case actually knew of that the defendant knew of his rights to a jury trial and whatnot. There was no substantial risk analysis. There was also a decision, and forgive me, in fact, I'd be happy to send a letter to the court, but I can't remember.
Is that still the test? That there has to be, that the defendant has to show a substantial risk of a miscarriage of justice if there is no written jury waiver?
I would argue no. And I think Amicus raised that issue in one of their briefs. That no, I don't believe that there is a substantial risk standard if, in the context of the bench.
Osborne sort of danced around that issue a little, right?
Yeah, I would, sure, yes.
I mean, I think it doesn't explicitly say we're cutting back Collado, but it...
Well, it says Collado was really an opposite. It
Yeah, but that's what
related
I'm
to
saying. So
another
dance-
situation.
Yeah, it didn't exactly take on Collado head-on.
No, this court certainly did not take on, but what I took away from Osborne is that in circumstances, again, not this case, of course, but in bench trial cases, that if that bright line rule isn't followed, then the court's not going to go through a prejudicial review standard, and the court's going to simply reverse the convictions.
I think that's a fair reading.
Thank you, Your Honor. Unless there are further
Mr.
questions.
Gold, you get the gold standard for today, for concluding your argument within the time.
Thank you, Your Honor.
Good morning, Mr. Clues.
As you know, I represent Corey Hubbard, and this is on the application for the further appellate review of the Commonwealth on the judgment of the appeals court. My understanding of the decision of the appeals court is that the colloquy didn't matter because it had to be that the writing was paramount in terms of memorializing the waiver in order to make the determination of the intelligent and voluntary waiver of the right to trial. So with respect to the colloquy is not an issue as to whether or not he was given his rights. Judge Lynch did include that it was her practice with regard, and that's all part of the brief.
Have we ever said, though, that the written waiver of the right to jury trial must be completed when a defendant pleads guilty?
Yes, it should be, and as a matter of fact, as part of practice, every green sheet or tender of plea, as they're called, are all signed, and in most cases, I didn't represent Mr. Hubbard in this case, but in most cases that I'm familiar with, the court will ask and hold up the green sheet. Is this your signature? And then there would be questions that would follow. Listen, you signed this. You had an opportunity to talk to counsel, and is this your free act? And so prior to any plea being taken, actually, there should be a determination, and usually there is a determination that the defendant has signed the waiver of his rights.
So hypothetically, if a judge went through a very thorough colloquy in which the judge explained all of the defendant's rights when they wanted to enter a guilty plea, but the judge didn't get a written statement, you would say that that was flawed?
I would say it's flawed, and primarily flawed, because before the colloquy even takes place, the green tender plea, as we refer to commonly as the green sheet, is before the judge. There's nothing that begins without that green sheet.
But is that, do you say that that's a requirement of rule, statute, case decisions, common law, the Constitution?
As to the signing of the waiver, Your Honor?
Yes.
It's a hard one. As I read 263.6, it says that, the way that I read it in a whole, is that what it says is that we're protecting the rights of defendants by requiring the waiver of the jury trial, trial by jury, and then go to a bench trial. So in order to answer the question, it's difficult for me because it's almost like being asked, which glass do I want, the one that's half full or half empty? When you plead guilty, as the court knows, I mean, that's a conviction, once that is accepted.
Right.
So you've waived every right that you possibly have. So to me, it's probably more constitutionally based from the standpoint of being able to make the determination when on appeal, and a case comes before this court or any other appellate court, to be able to make a determination whether there was a voluntary, knowing, and intelligent waiver of the right. And there is no more right important than the trial by jury. I would think that all you're giving up in a jury-waived trial is the jury.
Mr. Clues, let me ask you this. If we flipped it on its head, let's assume that we had a green sheet in a plea case, not in a bench trial, in a plea case. You have the green sheet that had been signed, but there was a clear record that no colloquy had been given.
Then I think
We would say big problem, correct?
Yes.
Big problem,
Yes,
because the
absolutely.
judge doesn't know whether the defendant really understood his or her rights and so on. It seems to me that the practice that you are describing, which I accept because you practice in the court so much, makes a great deal of sense for the following reason. We know that as a matter of court rule, the district court automatically destroys its tape recordings, after a certain period of time, quite a short period of time, actually. And so one thing about having the green sheet is that at least it's some indication that the colloquy was given. It's not determinative, but it's some indication. But if it appears not to be required by statute, and as Justice Ireland says, the full colloquy has been given, and Judge Lynch in her recitation of what she typically did, it's a pretty fulsome one, where are any of the constitutional rights of the defendant impaired from your point of view?
From my point of view is that they're impaired because a reviewing court has no way of telling whether or not the plea was voluntary and knowledgeably and intelligently waived. That if Your Honor, please, it's become a matter of practice that, and even in the Superior Court, there is a waiver of rights, and that is signed in every single case. Now, since it's been before the courts, I've never had a case in Superior Court, and actually, since I guess it's 1992 or whenever the green sheets came out on this, I haven't had a case where there's ever been a plea without the memorialization of it. And that, I think, is for, as the court's indicated, for protection of the record. If in the district court where the tapes are destroyed, that there's some place that the court can go to make the ultimate determination as to whether or not the waiver was valid.
Well, let me ask you then, if you had a situation, again, a hypothetical situation, where there was a full colloquy, but the tapes were not destroyed, the tapes were available, and we could then, the appellate court could listen to what the defendant was told, would there be a problem then? With no writing, no signed waiver, but you have a record of the colloquy.
I think if there is a problem, it's far less of a problem than we have right now. And with the decision of the appeals court on the Hubbard case, it says that one without the other, the colloquy without the waiver, as it viewed this case, or a waiver, signed waiver without the colloquy, are invalid on their face. That's the position of the appeals court. So if there is an opportunity and if the tapes are there, really the ultimate decision is making by the court, a reviewing court, as to whether or not the waiver took place in the manner that's required, I suggest constitutionally, with the knowledge and the voluntariness and the intelligence of the defendant.
Mr. Cruz, what do we make of, and I haven't gone back and read the briefs, of the two other appeals court decisions to which the Commonwealth, 128 decisions to which the Commonwealth has drawn our attention, Scialdone and Valderrama?
Well, they're opposite each other, and the other justices on those cases took the position that 263-6 did not apply,
Does not.
that there was no need to have a signed waiver, as it didn't apply because of the statute.
Well, except that we have one justice who is sitting on both panels, right?
No, well, not if Scialdone.
I believe it was. But the statute, to me, is clear, that was applying to jury waived trials. But the beginning of the statute indicates, and I have trouble with this, I think I could anticipate an answer if I was actually posing the question. But under 263.6, it says that when called upon to plead, I mean, if we're taking that to mean that call upon to plead means entry into court and at an arraignment and entering a not guilty plea, which it could, I take it to be all-inclusive. It's that when it's time to plead, because it says that when called upon to plead and at some time later, before a jury is impaneled, that the waiver must be signed and submitted to the clerk.
Except that if you go on to the next sentence, which talks about the court's waiver, as you know, it says if the court accepts the waiver, he shall be tried.
That's right.
But, by bench trial, which suggests that...
I understand that.
Do you know when 236 Section 6 was first enacted? Was it before the green sheets came into...
I believe it was, yes.
Okay.
Yes. That much I believe it was. I have nothing further that I can
Well, then
argue
you
because it's just...
really do get the gold star, because you did your argument in 5 instead of 7 minutes. So sorry, Mr. Gold, you get the silver. Thank you, Mr. Cruz.